Well, it's a real pleasure to be speaking with you this afternoon, on this sunny afternoon, about LLP disputes. Over time, it's become much more common for these to come across employment lawyers' desks. And I should have said to people, put your phones on silent, please. These disputes have also become much more numerous. Now, I lead the partnership and LLP group here, and we've seen an increasing number of what I would describe as crossover cases. That's to say, cases that raise classic issues of LLP and partnership law on the one hand, and discrimination and whistleblowing law on the other. And again, I think that those disputes are very much on the uptick. The most common two talk requests I get are either to talk about equalities and whistleblowing law to partnership lawyers, or to talk about partnership law and LLP law to employment lawyers. So this is obviously in the second category. And one effect of that is that I'm going to be taking for granted a large amount of knowledge on the audience, on all of your parts, about discrimination law and whistleblowing law. And I'm going to be talking much more about the partnership and LLP concepts that you may have encountered far less. I was meant to be speaking today with Mo Sethi, Casey, who's a very valued member of our partnership team, indeed, who I often speak with on occasions such as this, but unfortunately he has had a family emergency, so it's me on my own. An advantage of that is that we may make up 5 minutes or so of the time, so that John and Nick can take you through the exciting world of Springboard to close off our day. So, as I said, the objective for today is to introduce you to the most common LLP disputes, to talk about the concepts and law relevant to them. And what I'll also be doing, and this is possibly slightly inexact exercise, is I'll be flagging those things that, if you like, are different from the senior executive employment disputes, which LLP disputes are often similar to. I wouldn't want you to take away from this talk that LLP disputes are wholly different, minefield terrain, that they're completely different from senior executive disputes, because that's not the case. There are significant areas of commonality, and there are undoubtedly areas where you as employment lawyers will find that it all sounds very familiar indeed. So taking this to the first slide, what are the most common disputes? Well, the first type of dispute is what I would loosely describe as an exit dispute. Now, in point of law, most often what one is dealing with is a proposal either to expel someone from an LLP or to retire them from an LLP. And this leads into a first sort of terminological point. In the LLP context, the word retirement is not necessarily, or indeed often, tied up with the statutory retirement or anything, age or anything like that. It is simply a process whereby someone is retired from the LLP. And most LLP deeds will have in them two types of provision. The first is an expulsion clause, which is pretty self-evident. And the second is a clause permitting either the management board or a majority of LLP members to give an LLP member notice to retire after a set number of months, 3, 6, in some cases 12. Now, what are the underlying events that lead into this unhappy situation? The first and most common are allegations of misconduct. The second are what one would loosely describe as performance issues. But it's a mistake to think that these are always conduct/capability type dismissals, if one was looking at it at an employment lawyer's eyes. One can often have situations where, for example, an LLP decides to close a particular area of its business, where it decides that it no longer wants to continue undertaking particular types of business, and partners are therefore going to be given notice. So that's the first type of dispute, exit disputes, which come in all shapes and sizes we're about to see. The second, I've described these as remuneration decisions. I think a more helpful word would actually just be money disputes. technically one can be looking at disputes over profit share, but one can also be looking at disputes over future monies that the LLP is meant to be receiving. And one can also be looking at disputes over monies people have tied up in an LLP. So it's not invariably the case, but it is very often the case that LLP members will have capital tied up in the LLP. And most LLP agreements will have quite involved provisions for return of capital either immediately or over a period of time, or with some of the capital being lost, although that's more unusual. And the key question in what brings all of these disparate disputes together is that the key issue as a lawyer is normally you're looking at how to challenge these decisions once they've been made, how to preempt challenges, particularly if you are advising the majority of the LLP or the management board, and then how to defend challenges if they have been brought. So that's the overview. Now, we now need to turn to the law. LLPs are creations of statute. The background to this is, I think, very well known, and many of you will have read newspaper coverage about it some 20 plus years ago. But in a nutshell, there was a particular concern that under the 1890 Partnership Act, partners faced potentially unlimited liability. And with the larger partnerships in particular, there was a concern at massive claims being made against the partnership, leading to the potential insolvency of large numbers of partners who had nothing at all to do with the wrongdoing in question. So the idea of the LLP Act was to give the benefit of limited liability to the traditional partnership. Now, there were significant problems with this conceptually, really at all stages. And an overview of one of the main difficulties that LLP lawyers face on a daily basis is this. You have some areas, the Company Act and Directors' Duties being a very good example, where it simply said, we're incorporating the previous law on directors' duties and we're going to codify it as follows for ease of reference. The LLP Act did not do that. It did not contain any provision incorporating previous partnership law or law under the 1890 Act. So you have to feel your way through the statute and the case law. And the key act remains the LLP Act 2000. There are then a series of LLP regulations made under it. The most important are the ones there because they contain the so-called default regulations, which I'm going to come to. Now, pursuant to Section 5 of the LLP Act, the mutual rights and duties of the members of an LLP and the mutual rights and duties of an LLP and its members, so you've got two sets of relationships, one being the purely horizontal relationship and the other being the relationship between the LLP and the members, are to be determined either by agreement between the members or by regulations. Now, one point I would make is that the word agreement generally means a document that's helpfully marked LLP deed, but that is not invariably the case. And in fact, I have had cases in the past where the agreement between the members has to be pieced together by looking at all sorts of email exchanges over a period of time. That will classify as an agreement between members, although obviously you can run into evidential issues. If there is no agreement, you look at the regulations. Now, before we turn back to the regulations, there is an important difference between LLP agreements and contracts of employment, which is that we're all very familiar as employment lawyers with constructive dismissal. Now, although there's now a codification of this in the Employment Rights Act, the basic principle of that concept remains very straightforward, that there has been a repudiatory breach of contract by the employer, which the employee has accepted, thereby declaring themselves constructively dismissed. In the context of LLPs, that argument has been decisively rejected, at least at first instance, in the case of Flanagan and Lion Trust. And what is held there is that the LLP agreement cannot be repudiated. So in other words, you cannot have a classic constructive dismissal from an LLP. And even if I were to change the word from dismissal through to a constructive expulsion, the same principle holds. So that's the key point about members' agreements. And the other key point about members' agreements is that in very many cases, the answer to all of the difficult questions that you're going to have about LLP law really depends in the first instance on construing the actual LLP agreement. It's far more important in many ways than in employment. One has an extensive statutory overlay, whereas in LLP law, it's the reverse. The contract is king, as one of my colleagues memorably says in court when you're arguing that his clients have behaved unreasonably. So what are the default rules? They're helpful to be aware of. Regulation 8 in the context of expulsion is absolutely critical. It says that no majority of LLP members can expel any member unless a power to do so has been conferred by express agreement between the members. So in other words, if you do not have a retirement or expulsion clause in your LLP deed, you do not have an option of applying to the court to expel a member. And that, for those of you who've done partnership law, is different, because under partnership law, there are various circumstances where you can make an application to the court to get rid of a partner. You can't do that in LLPs. And so your options can be really very unattractive. You can look at potentially winding up the LLP, which is obviously a draconian step, or you can look at unfair prejudice relief, which again is a highly unusual case in LLP law. It is an extraordinarily cumbersome way of achieving an expulsion, and very few people look at it. Moreover, the right to bring an unfair prejudice petition can be excluded expressly by an LLP deed, and over 90% of the LLP deeds expressly exclude that power. So essentially, you're looking at the contractual wording of the expulsion clause. And it follows, therefore, that the first issue is construction of the express terms of the expulsion or retirement clause. Then the second issue is, what implied terms can there be? And this is something that very often catches people out. You can be aware that in LLP's contract is king, you can see an express term permitting an expulsion, and you can say, well, that's the end of it. Well, that is not the end of it, because there are a series of implied terms that you need to consider. Now, the third thing I've put there separately, equitable principles. Technically speaking, equitable principles are normally applied by way of an implied term. But I think it is always important to consider equitable principles for a reason I can explain very shortly. Let's say that you have an expulsion clause that seems fairly clear, but elsewhere in your LLP agreement, you have a term that says that the members of the LLP owe one another a duty of good faith. That is a contractual importing of equitable principles from partnership law, and it's very important in the exercise of a power to expel. And it is also the case that very often when these cases do come to courts, or more commonly arbitrators, you will find that an arbitrator will very often start by saying, well, what about the equitable law on partnership? How is that relevant? So that's why I've put it as a separate heading. And then finally, the areas that you will all know very well. It's the Equality Act 2010, the Employment Rights Act 1996. So that is the overview of these are the questions you need to be thinking about when you're dealing with a putative or actual expulsion. Now, within the context of fault-based expulsion, there is, in general terms, a split between two types of wordings. One is a wording that says if a member has been guilty of serious breaches, then the majority may expel them. Now, that wording is quite important for reasons I'm going to come on to. The second type of clause is one that gives an opinion of the management committee sway in this issue. And then we have the separate issue of no fault compulsory retirement. And generally speaking, no fault compulsory retirement clauses are very bare. They don't say very much. So if one is looking at a fault-based expulsion, the first thing you need to do is to construe the clause. If its effect is that there has to have been a serious breach, then that is an objective question. And to give an example of why that really matters, let us take the classic case. I'm afraid it is a classic case, sadly. There is a situation where an LLP has had very serious allegations made to it about the conduct of a partner. In that context, a decision is made that the LLP is not going to name the complainant. The potential risk, if there is an objective wording in the clause, is that if the case goes all the way to an arbitration, commonly, the LLP is going to face an evidential problem, because it is going to need to show that the actual facts alleged, i.e. that the serious breach has occurred. And there are various ways of attempting to patch that up. I'm not going to go into the rules of evidence. Suffice it to say, of course, that you do not always need a complainant to give evidence, but it is clearly a problem. Conversely, if one has an opinion type expulsion wording, the focus is going to be on the management board, the members of the management board, and the decision they made. Now, not all LLPs have management boards. Quite a few LLPs still have expulsion decisions being made by the entirety of the LLP. And again, thinking about it with a litigator's hat on, the key issue there is going to be that someone, possibly even multiple people, are going to have to come and give evidence to an arbitrator or to the court about why they reached the decision that they reached. So that's the key issue on construction. Now, the next question, which I think is very relevant indeed to employment laws, is what does the word serious breach mean? Now, I'm not going to attempt to explain the law of wrongful dismissal in employment. It's a different talk. But suffice it to say that a serious breach of a members' agreement, the test is actually lower than the test for repudiatory conduct under an employment contract. And that is clarified in the very recent decision in THJ Systems Limited and Sheridan and another. And what that shows is that a serious breach does not have to be a repudiatory breach. And that's a significant point. You can then have wording about repeated breaches, whereby I think the answer is fairly straightforward. So those are the common contractual issues on the express wordings you usually find. The next question is, okay, that is your express wording. Where do we stand on, and I've lumped them all together, fetters, implied term, good faith. Very often, this is three ways of describing the same thing, but they can be different. Now, fetters and good faith are both really classic concepts from the old-fashioned law of partnership. Implied terms, much more commonly, of course, encountered. So the next question, as I say, as you go through, well, what are the fetters on the decision maker or decision makers? And I referred to the traditional law, and I've got a very old case for you, Blissett and Daniel, from before the 1890 Partnership Act, still cited very frequently today. And what Blissett and Daniel says is that there is a duty of good faith on the partners when deciding whether to expel a fellow partner. So that's obviously a very important principle. And then I know that you have had a talk earlier today on bonus disputes, which is why I'm going to talk about remuneration a bit less than I would otherwise do. And you will have been through, in fact, I know that you did go through the case of Braganza and BP Shipping Limited, undoubtedly a leading authority. And there, just to summarize, I suspect, a talk you've already heard, we've got these duties to take into account relevant considerations, leave out of account irrelevant considerations, and then reach a decision which is objectively reasonable. Now, that is commonly referred to in this context as a Braganza implied term. And one can see an overlap between it and good faith, but they are different, and I'm going to explain that in a moment. Now, where things start to get a bit complicated is this. Blissett and Daniel, as I say, is a case in an old-fashioned partnership. LLPs are not old-fashioned partnerships. And one of the earliest cases to litigate was a case which did not concern a partnership with real people in many ways. It concerned an investment partnership, and a lot of LLPs are investment partnerships. And there, what one saw was that the High Court, Mr. Justice Sales, as he then was, said that it is not the case that a duty of good faith always arises under LLP law. And I'm sure that there were, well, I haven't read the decision, I can say there were many valid reasons for that decision. But I have to say that as a working LLP lawyer, this creates this problem that you're very often saying, well, is there a duty of good faith here or not? And that position is complicated by the following things. The first is, as I've already indicated, many LLP deeds contain good faith terms. So the members will behave to one another with utmost good faith, or the members will behave to the LLP with utmost good faith. So you need to consider the effect of those. But then we have the general view among practitioners, confirmed to an extent by Eaton and Caulfield, that a duty of good faith, even if it is not expressly stated in the deed, may be owed in limited circumstances. And the key circumstance here is expulsion. So the argument here goes like this. Even if there is not always a duty of good faith in LLPs, even if that duty may not apply to some types of LLPs, for example, pure investment LLPs, if you're looking at a working professional or other services partnership, it is very likely that before the majority or the management board exercise a power to expel, they have to behave in good faith. And that is a subject on which there are many council's opinions and arbitrators' decisions flying around London, or perhaps not flying, but anyway, they're circulating. But I think that it would be fairly rare these days to find an arbitrator or a court who would hold that there is no duty of good faith on a majority when exercising a power of expulsion. So that's the complicated point, hopefully taken in only 3 bullet points. So there you go. What does good faith mean in practice? This is a question I'm very commonly asked. People say, well, we're very interested to hear your talk about good faith. And what does it actually mean? Well, that's a very valid point. Good faith, to behave in bad faith, does not necessarily mean that you have behaved dishonestly. So, and that's again confirmed in the THJ Systems case. But crucially for our purposes, there are cases that suggest, and THJ is one of them, that this is going to involve a minimum standard of fairness. And what does that mean? Well, as employment lawyers, you'll be very, very well familiar with the principle that before dismissing an employee, the employee should be given an opportunity to respond to the case against them. And interestingly, in THJ, which is an LLP case, the court was persuaded by a submission by reference to Audace Group Limited, which is a company case. And to make things even more complicated, that was a quasi-partnership case. I'm not going to further complicate things with having quasi-partnerships. But what Audace Group Limited holds is that there is a minimum standard of fairness. You have to give someone the opportunity to express their case. Now, there are cases, such as THJ itself, where the court that can be persuaded that this does not necessarily mean having a full meeting with a note taker and everyone going through everything very carefully. And in THJ, the court said, well, that wasn't necessary because there'd been an exchange of views between the 2 key LLP members. And I think at the time they remained the only 2. There'd been an exchange of views. The member who was excluded was fully aware of what was being complained of. he had an opportunity to set out his view, and then a decision was made to expel or to give notice. So in that context, I think one can say it's not quite the same as an employment law analysis, but it's very similar to it when you get right down to it. So that's where good faith takes us practically. The other point I should make about good faith, just very, very briefly, is a common issue that arises is arguments about ulterior motive. And for reasons I don't entirely understand, this seems to be argued more in the context of LLPs than it is in the context of senior executive dismissals. But what's very often said is, oh, well, the people who decided to expel this person wanted this person out because they would profit by being promoted or whatever. Well, that is, I think, quite a difficult argument in terms of a good faith argument. There's no clear case law on it, but I think it's a difficult argument. But I mention it because you can very often have a situation where a sort of preemptive strike is launched, and it can be said that all of the members of the management board are quote unquote conflicted. And I think that's a very difficult argument actually to succeed on. So procedural fairness. Now, I've referred to the Aldas Group case. Whittaker, I've referred to it as W&M. It's Whittaker and Machel on LLP law, which is a commonly used practitioner book. And what they say on this is that the role of procedural justice in the exercise of a power to expel is not wholly clear. Well, there you go. Well, very often that is the case with LLP law. Someone gives you a careful opinion, which is that the position isn't clear. I think my view about it is very simple. There is a certain amount of case law. I haven't burdened the slides with it. There's a certain amount of case law about natural justice broadly. You get these kind of cases where people are not in a classic employment relationship, but something that feels very like it. And I think that if you look at those cases, for example, there are cases on unincorporated associations and things like that. If you look at those cases, you can find that the courts will tend to say there is a natural justice point about hearing the other party, hearing what they have to say. By contrast, what you're very unlikely to get traction with in an LLP case is an argument that, oh, well, you know, I should have had someone accompany me at the meeting, for example. That kind of argument is, I think, more difficult. That's not to say that in all facts it will fail. A very simple example is that it may well be a reasonable adjustment to permit someone to be accompanied to a meeting, but that will not arise as an incident of contract. It will arise as an incident of the Equality Act or the duties arising under that. And I've discovered the right to respond. And to round it up, I think that there is a significant risk for an LLP majority that decides to proceed to expel without having given someone a right to respond to allegations. So there we go. Now we have no fault compulsory retirement. And I think it's useful we've done it in this order, because often when you explain to the management board or the decision makers that there are these potential wrinkles about an outright expulsion, attention can suddenly focus on a no fault compulsory retirement clause. And the advantage of these for LLPs is that there is no case finding that a Braganza duty definitely arises. So in other words, that whole set of constraints on decision making may not arise at all. Equally, there is no case the other way. What one is really ended up, and these cases have been cited at me before, and I've probably cited some of them before. I point out to everyone immediately, again, they're not LLP cases. They are wording on equivalent, they are decisions on equivalent wordings or rights in other contexts. But what is said in both cases is that if there is a right to terminate, that is not a discretion. That is a contractual right conferred on the majority. The difficult question is, nevertheless, can you argue for an implied good faith duty? Well, I've seen this argued both ways a number of times. Increasingly, I am persuaded of the idea that there is some constraint on the exercise of this power. I'm not quite clear how strong that constraint is, But I definitely think that if you are advising an LLP member who has been peremptorily retired without any explanation and in murky circumstances, it may be worth an argument. In fact, it often is worth an argument. The question of whether your client will want to proceed all the way through litigation in circumstances where there is not clear case law is of course a different one. So that's no fault compulsory retirement. An advantage of no fault compulsory retirement, typically for LLP members who are the subject to it, is that most LLP deeds are much more generous as regards the financial entitlements of people who are subject to a no fault compulsory retirement than they are as regards people who are outrightly expelled. So that's something to bear in mind. The next question becomes, let's say that the LLP majority have expelled wrongfully. What follows from that? Well, under old-fashioned partnership law, it follows that the partner has simply not been expelled. And that's very significant because the partner will have a prima facie financial entitlement to the profits made by the LLP or to their share of the profits made by the LLP during that period. In LLP law, there are two cases now. One is Ilott and Williams. That suggests that you simply have a claim in damages, the money that you would have earned if you'd remained a member. The partnership book, L&B, another abbreviation on my part, Lindley and Banks on partnership, not a book on LLPs, but very, very clear in its views of LLPs. It says that Ilott and Williams is wrong and that the correct position is that the LLP member would remain. THJ Systems very recently was argued on the basis that invalidity would follow. In other words, that if the notice was successfully challenged, it would follow that the individual had remained a member of the LLP. Why does this matter? Well, the reason it matters is that the financial consequences are very markedly different. Because if the damages analysis holds true, then there is a serious question mark as to whether they should be capped at the notice period. So let's again go back to the 3-month notice. Is it the case that if you're wrongfully expelled, your claim is capped at 3 months? Or can you make an open-ended claim? Does the kind of employment law, case law about most efficient termination apply? Mullins and Lawton suggest that that case law does not apply and that you have a claim for damages at large. Conversely, if your damages were capped at the notice period, then you could start getting into the territory of the injunctions you can see, for example, in medical cases, where there's an attempt to restrain a dismissal or a dismissal process before it has run its course. And that's quite a specialist area. There is no comparative LLP case law. I have seen these injunctions threatened. The circumstance in which they are relevant, to cut to the bottom line, they become very relevant if an LLP member is going to become entitled to a defined sum of money at a particular date. So if you have a situation where the profits of an LLP are distributed according to a so-called waterfall on date X, and the effect of the notice is that an LLP member is going to not be a member at the time of the waterfall distribution, then it's really in that circumstance that you will get into the business of threatening an injunction or having to advise the client of the risk of an injunction application. But I mention again that there is no comparative case law in the LLP context, and as everyone who has had to dabble in the medical cases will know, or has got caught up in them, one can look at the authorities one day and think it's very easy to get an injunction, and then you look at them the next day and you say, oh well, it's all a bit more complicated. So unsurprisingly, no one's really gone for it. Now that covers the key partnership and contractual practical issues that arise. I'm now going to cover the discrimination aspect, but I'm going to cover it more briefly because of the knowledge in this room. So the basics of the Equality Act, we all know: protected characteristics, the prohibitions. I just draw out particularly section 19, indirect discrimination. It can be more important in the LLP context than in others, particularly if performance financial metrics are used to justify an expulsion, which can quite often be the case. And there you can get into NAIM and ESOP and so on. So after that framework, let's look at how it works in an LLP context. Well, sections 44 to 6 of the Equality Act, a firm must not discriminate against B as the terms on which B is a partner member. That's quite important. That's a very broad set of wordings. It would encompass profit share, for example. Expulsion, self-evident, subjecting B to any other detriment. And as we know as employment lawyers, that's a very, very broad concept indeed. I'd also note that there's an extended definition of expulsion, which is important for reasons I'm about to come to. And then we have the classic prohibitions of harassment and victimization. So we can see that it does all apply. Now, I talked earlier about how contractually you can't have a constructive dismissal from an LLP. Now, in the case of Roberts and Wilson solicitors, the Court of Appeal made a very important decision because in that particular case, Mr. Roberts sought to declare himself constructively dismissed from the LLP, withheld labour, and the LLP then duly said, well, you have failed to comply with your obligations under the deed, we're expelling you. And the LLP then ran the argument in an employment tribunal that the effect of Flanagan and Lyons Trust was that what Mr. Roberts had been trying to do was hopeless, and therefore that any attempt by him to claim something looking like constructive dismissal damages was doomed to fail. And the employment tribunal accepted that analysis, but the Court of Appeal did not. And what the Court of Appeal held was that the chain of causation and detriment and loss was not broken automatically by the LLP's subsequent decision to expel, even if that subsequent decision was justified in point of contract law. So the effect of this is that although you cannot contractually have a constructive dismissal from an LLP, when you are dealing with discrimination or whistleblowing claims, and that case is a whistleblowing claim, you have this possibility of saying that you as an LLP member have been put into this position, you've suffered detriment, and yes, you have stopped working for the LLP, but that's an issue really fundamentally of mitigation and for the tribunal to form a view about having heard the full evidence. And that's particularly important if you are advising LLP members who feel locked in and without a remedy. So that's the point on that. Now, I mentioned that I pick up on indirect discrimination, proportionate means of achieving a legitimate aim. I am persuaded, and in fact, I've given talks on this issue, that the application of indirect discrimination law to LLPs, particularly large professional services firms, is going to be an important area going forward. Because time and again, one will see expulsions or more the giving of notice, forced retirements, justified by reference to financial metrics. And the truth of the matter there is that in a tribunal setting, there is going to be a simple question about, is this proportionate? Is the aim legitimate? And as we all know, that is a question of fact for an employment tribunal. And some of these very, and I use the word loosely, macho approaches, your numbers are not up to speed, so you're out of the door, approaches, I think are much more vulnerable to these type of challenges than people may appreciate. The problem with them, as we all know, is that indirect discrimination claims are fiddly, to say the least, to litigate. But there we are. So that's indirect discrimination. I've already talked about financial targets. There's a key distinction there. Is it the target itself that you're attacking, or is it a discriminatory application of them? For example, what allowances have been made when someone has returned from maternity leave or from a period of illness, etc. On analysis, two different types of claim. Then we have Selden and Clarkson, Wright and Jakes. I have lost count of the number of times I have been told in letters that Selden and Clarkson, Wright and Jakes establishes that a firm may have a mandatory retirement age. That is a decision that was reached by the Ashford Employment Tribunal on the facts of that case. It is not a general statement of the law. Again, a firm is going to need to justify its position. Having said which, I think it's fair to say that the general direction of travel in those cases, and your experiences may be different, is that I think that at the moment, the principle of retirement at a certain age seems to be slightly doing better than it was 5-10 years ago, but we shall wait and see. Then one has wider issues about organizational culture. That's really a separate series of issues, which you can easily see how that ties in with discrimination law. Now, having flagged the key discrimination issues most commonly encountered, I'm just going to mention whistleblowing. Now, I'm not going to take you through the law of whistleblowing because you will all know it. But I flagged that when you're considering the public interest test in LLPs, you can run into quite an interesting question which goes like this. We know from Chesterton and Nur Mohammed that a disclosure can be in the public interest if it is in the interests of a relatively small subset of people. And one of the issues that you can have in an LLP context is if someone says, I am disclosing this to my fellow partners because I think that they have a collective interest in knowing about what has been going on in the LLP. You have an interesting question as to is that in the public interest or not? Now, I've mentioned the other cases which you will all be familiar with, but I just flagged that this public interest argument in LLPs can be quite nuanced and quite interesting, because in many cases the counter argument is no, you haven't disclosed this to the other partners for that reason. You've disclosed it because someone has told you to disclose it, so you can bring a whistleblowing claim, which is obviously something that never happens. So we then have what's the other key issue? Interplay with regulatory issues. Very, very common now to have this. I'm not going to get into the detail of the SRA and its changing approaches, or the FCA and its approaches, but suffice it to say that it is very, very common now in LLP cases to have a regulatory angle to this. Then we have the mixed motive cases and FECIT, and then we have the rock on which so many whistleblowing cases founder, namely causation, about which I will say nothing more. So having dealt with the meat of the talk, I'm going to deal with compensation disputes. And I'm keeping the slides on this brief for a variety of reasons. The first being I want to pass over to John and Nick. But the second is that the more I have been involved in these, the more I think that they are heavily fact sensitive, heavily dependent upon the wording of the deeds. And in terms of the law, I'll simply make the following points. I generally see most of these cases, not all, the bonus cases are being commonly argued, Keene and Commerzbank, etc. We then have Braganza, which interestingly, in its reference on the bonus cases, suggests a relatively clement type of review. In other words, that the court is not going to expect an LLP to act like a public authority. Tribe and Elborn-Mitchell is very interesting. Conceded that this was all discretionary, and it was conceded that a duty of good faith applied to the decision as to distribution. I personally wouldn't have made that concession, but that is what happened. And the short answer is, if that applies, it's C above. In other words, you will see the arguments applied about breaches of duty of good faith. Really matters a lot when people are about to be turfed out. Now, what is the common approach? I think having started late, I think we're getting back towards timekeeping parity. Now, what is the common approach? This is the only picture of my slide, the black box. There is a school of thought which says that if you're exercising a discretion, you keep your powder dry, you don't explain in great detail why you've made the decision, and you let it all come out as a matter of evidence later. There are risks in that, not least because people can say, well, this isn't really your decision making, this is something that you've made up after the event. But clearly, it's very important if you are for the individual to try and get the LLP or its managing board to explain the reasoning as far as possible. And there are various ways in LLP law you can have a go at doing that. For example, you can ask your fellow members to render a true account of what has happened. You can have a go at getting the records of the LLP and so on. So that covers almost everything. What are the less common claims? Well, I'm going to deal with these at lightning speed. The first is profit share as wages and equal pay legislation remains to be substantially tested in the LLP field. The second is this argument that TUPE applies to LLP members by virtue of the definitions in the TUPE regs. And that can give rise to two consequences. First of all, a right to object, covenants fall away argument. And secondly, a claim in respect of failure to consult. It's a very niche issue, this, but a very interesting one if you ever have it. And then finally, the $64 million question. Are we going to get into a position soon when LLP members can bring unfair dismissal claims? The answer is Reinhard and Ondra holds not at present. Bates van Winklehoff suggested it might occur. It's going to be a very, very interesting one to see how that evolves. It's something that is open at Court of Appeal and Supreme Court level, and it's going to be very interesting. The next question is changes to taxation rules that may sort of undercut some of the commercial justification for LLPs, but I'm not going to start talking to you about film finance or football presenters. And finally, last slide, practical considerations. You'd have noticed that time and again today I've said, well, the better view is this, there's this one case or there are two cases. Why is there this dearth of case law some 20 years into the existence of LLPs? Answer is arbitration clauses in a nutshell. Nearly all LLP agreements contain arbitration clauses. The material point to mention here is that an arbitration clause will not prevent someone litigating Employment Rights Act or Equality Act claims in employment tribunals. And that is one of the many reasons why I think that when you're approaching LLP disputes, it is always very sensible to have in your armory the full array of statutory claims.